Much obliged. If it may please this honorable court, this is the counsel appearing on behalf of the appellant in the case of Christo versus State. If your lordships are well versed with the facts and the jurisdiction of the case, the counsel seeks permission to move on to the issues at hand.
Yes.
Much obliged, your lordships. I will deal with the first issue, which is whether the essential ingredients of sections 299, 300, and 201 of the Frisk Penal Code have been fulfilled in the present case. And my co-counsel will deal with the second issue while arguing that the case has not been proved beyond reasonable doubt. With respect to the first issue, your lordships, I'll be making three submissions. Firstly, it is contended that the elements of voluntary culpable homicide under section 299 are not fulfilled in the present case. Your lordships, there are two ingredients to constitute voluntary culpable homicide: actus reus and mens rea. Firstly, actus reus is the wrongful act of the accused that caused the victim's death, which means that it should have a direct and distinct relation between the act and the death. Your lordships, the present case primarily relies on circumstantial evidence, and the Supreme Court has importantly held in the case of Prem Thakur versus State of Punjab that where the circumstantial evidence only shows that the accused and the victim were last seen together, it is not sufficient to prove actus reus. In the present case, your lordships, there are three primary contentions with regards to the same. Firstly, the primary fact relied upon by the respondents is Christo's confession, which, as will be explained in our further arguments, is not admissible in this court. Further, merely showing that Christo and Lionel were last seen together is not sufficient to prove actus reus, even more when we cannot place reliance on the testimony of Mr. Chanston. Furthermore, your lordships, this means that the last time they were seen together was by Mr. Peake on the way back to Lionel's home on the motorcycle. Following this, secondly, the accused left Lionel's company and went back home before the incident even occurred, for which he provided a reasonable justification as well. Moreover, the weapon has also not been recovered to support the respondent's case. Thirdly, your lordships, it is a requirement that the circumstantial evidence should only point towards the accused's guilt and eliminate any other possibility. In the present case, however, the police have themselves admitted that crimes were on the rise in Kildare, and they weren't themselves able to handle the law and order situation. This increases the possibility of any sort of theft or robbery related assault happening as well, which gives rise to multiple possibilities in the case. And your lordships, for this very reason, we cannot rely on the testimony of Lionel's father, Mr. Pep, because of two reasons. Firstly, he stated that Lionel's belongings appeared to be on him, which is clearly stated in para 11, subclause 7 of the Moot propositions. Are your lordships with me?
Yes.
Much obliged. This paragraph, this statement raises doubt about his knowledge of the belongings in the first place, along with the fact that he was not aware about Lionel regularly lending money to Christo, which is clearly mentioned in para 12, subclause 5 of the Moot propositions. Moving on to the second aspect of this submission, your lordships, which is with regards to mens rea, which includes intention or knowledge, and it has to be established beyond reasonable doubt to constitute voluntary culpable homicide. Your lordships, the primary argument used to establish mens rea by the prosecution is the presence of motive. There are two aspects which I am contending here. Firstly, the non-sufficient nature of the motive. Your lordships, motive is an ulterior cause, which does not always translate to intention. In the present case, nobody had seen Lionel and Christo have any sort of argument ever, and they were good friends. There was no sort of animosity on the accused's part towards the deceased. Furthermore, your lordship, there are two aspects of motive here which have been contended by the prosecution. Firstly, the alleged jealousy, and secondly, the friendly borrowing between them. With respect to the jealousy, I have three contentions. First, there is no mention of jealousy or any other fact in the proposition from which jealousy can be inferred on Christo's part. Secondly, your lordship's coach Jose genuinely believed Lionel to be a better player, and that is not favoritism because it is indeed his responsibility as a coach. And thirdly, your lordships, the facts state that Christo's peers felt that he should play ahead of Lionel. However, there is no indication that they conveyed this to Christo or that his peers' feelings cannot indicate or dictate what he felt about Lionel, considering that both Christo and Lionel were very fast friends. The second aspect of motive contended by the prosecution is regarding the friendly borrowing between the two. Your Lordships, what is evident from paragraph number 4 of the proposition is Christo's knowledge that the money was a loan, and it also shows his willingness to pay back the money when he promised that we would pay it back at the earliest. Christo had all the intention to pay back the money owed by him to Lionel, your Lordship, and there is no indication in the fact sheet as to why this trend would not continue in the future. And therefore, he did not have any reason to kill Lionel in the first place. Your Lordships, it is humbly submitted that such possibility of trifle arguments cannot be said to constitute mens rea, since even if there is one doubt about the presence of sufficient motive, the accused cannot be convicted since the crime cannot be established beyond reasonable doubt. In addition to that, your Lordships, the Supreme Court has clearly stated in the case of Sampath Kumar versus Inspector of Police that motive cannot lead to conviction in a case of circumstantial evidence when the chain of circumstances is not complete. The court in this case, your Lordships, disregarded motive even when the case was based on circumstantial evidence, since the chain of events was not complete, and the court further stated that howsoever strong a suspicion may be on the accused due to the motive, it cannot substitute proof for a crime beyond reasonable doubt, which is similar to the present case, your Lordships. And therefore, it is submitted that the elements of voluntary culpable homicide are not fulfilled in the present case, since firstly, actus reus, that is the wrongful act, is not proven, and secondly, mens rea, that is the intention or the mental state to commit the act, is not present. Your Lordships, moving on to the second submission, it is contended that the ingredients of murder under section 300 are not fulfilled in the present case. Your Lordships, there are two elements. Firstly, a combined reading of section 299 and 300 clarifies that voluntary culpable homicide is the broader terminology, and the offense of murder falls under it. And therefore, in the absence of the fulfillment of the essentials of voluntary culpable homicide, the offense of murder cannot be concluded. And in the present case, as argued previously, the two elements of voluntary culpable homicide, which is actus reus and mens rea, cannot be proven beyond reasonable doubt. Secondly, to constitute murder, your Lordships, the case must not fall under any of the exceptions of murder. Your Lordships, as an arguendo, assuming but not admitting that Mr. 𝐶𝐻𝐿ton's testimony is relied upon, it is contended that there is a possibility of the case falling under at least one of the exceptions of murder. If your Lordships would refer to para 24 on page 10 of the memorial, if your Lordships are with me. Your Lordships, there is a possibility of the case falling under the exception of sudden argument. It is an unpremeditated assault in the heat of the moment, which occurs due to a sudden quarrel between both the parties. Your Lordship, in several instances, the accused has not been convicted for murder in the absence of any previous quarrels between both the parties, since animus could not be established between them. In the present case, your Lordships, there are three aspects to this argument. Firstly, there was no previous quarrel between my client and the deceased, which is substantiated by the testimony of Coach Jose. Christo and Lionel, your Lordships, casually met for dinner and went to Bob's Butchery, which was their favorite restaurant, which shows their close relationship, followed by a smoke break. Secondly, your Lordships, as previously mentioned, assuming but not admitting that Mr. 𝐶𝐻𝐿ton's testimony is relied upon by this honorable court, he stated that a loud, heated conversation took place between them at the same time and place, which shows that there was a quarrel where both the parties were arguing with each other. Lastly, your Lordships, there was only one injury, which is clear from clarification number 8, which occurred in the heat of the moment due to the sudden quarrel and in a fit of rage. And your Lordships, there was no further attack with the intention to cause the victim's death. And therefore, it is submitted that the essentials of murder under section 300 are not fulfilled, since firstly, the elements of voluntary culpable homicide are not fulfilled, and secondly, the case falls under at least one of the exceptions of murder. Moving on to the final submission, your Lordships, which is with regards to which is with regards to section 201, it is humbly submitted that the elements of section 201 have not been fulfilled in the present case. Your Lordships, there are two elements which have to be fulfilled to establish a charge under section 201. Firstly, that an offense has been committed, or that the accused had knowledge or reason to believe that such offense has been committed. And secondly, your Lordships, that with such knowledge or belief, he caused the disappearance of evidence related to the offense with the intention to avoid legal punishment. The first element, your Lordships, in this case is not fulfilled since the offense cannot be proven beyond reasonable doubt in the first place. For the second element, there are two submissions. Firstly, with respect to the disappearance of the weapon, and secondly, with respect to the disappearance of the dead body. Your Lordship, firstly, the accused is not liable for the disappearance of the weapon. There are three aspects to it, Your Lordships: the inadmissibility of the confession, the difference between confession and admission, and the non-recovery of the murder weapon. Your Lordships, the respondent's case is primarily based on the accused's alleged confession. However, as per section 164 of the Code of Criminal Procedure, such confessions have to be made before a magistrate to be admissible in court, since otherwise there is a probability of coercion by the police to extract a confession. In the present case, Your Lordships, the police took Christo to the local station, and upon fierce questioning, he gave a disclosure statement to them. Secondly, Your Lordship, it is crucial to highlight the difference between confession and admission, where confession is a statement about the crime itself, and it is not any other incriminating fact in relation to the crime. Your Lordships, in the present case, it is humbly submitted that the statement of the accused is indeed a confession and not an admission, because it states the alleged cause and manner of the death. Lastly, Your Lordships, the case of Ankush Wadhwa versus State of Rajasthan held that in a case where the weapon has not been recovered, the charge under section 201 cannot be leveled against the accused unless it is conclusively proven that it was the accused who destroyed the weapon. Your Lordships, in the present case, the murder weapon has neither been identified nor it has been recovered, and there is no evidence to indicate that Christo hid the alleged murder weapon. Moving on to the final submission, Your Lordships, the accused cannot be held liable for the disappearance of the dead body. Your Lordships, for this argument, we rely on the case of Hemraj versus State of Rajasthan, wherein it was clearly held that merely identifying the body's location after the police has already found the body cannot lead to an adverse inference to be drawn against the accused. In the present case, Your Lordships, the deceased body was found in a ditch a few blocks away from Lionel's home, and the accused allegedly identified the spot where his body was found. However, Your Lordships, mere such identification cannot lead to the accused's conviction, since there is no evidence to show that it was my client who dumped Lionel's body at the said place. This is further proven by the fact, Your Lordships, that no new fact or information has been discovered after or subsequent to Christo's confession, which further makes the confession inadmissible in this honorable court. And therefore, it is submitted that the essentials of section 201 are not fulfilled in the present case, since firstly, it cannot be proven beyond reasonable doubt that the accused committed the offense or had knowledge about it. And secondly, no evidence shows that the accused caused the disappearance of the murder weapon or the body. If Your Lordships are satisfied, my co-counsel will now deal with the second issue at hand. Much obliged, Your Lordships.
Yes.
Thank you so much, Madam Counsel. Thank you so much, judges. Judges, please note that Speaker 2 from Team URN 1876 will present the arguments now. Mr. Counsel, please begin with the submissions. Thank you.
Your Lordships, am I clearly audible and visible?
Yes.
Much obliged. Your Lordship, I am the second counsel appearing on behalf of the respondents in the given case, and I shall be dealing with the second issue at hand, which is whether the trial court has correctly applied the applicable tests of proving facts beyond reasonable doubt. Your Lordship, in the given case, both circumstantial and ocular evidences were relied upon by the Honorable Trial Court and the prosecution. However, before this Honorable Court, the circumstantial evidences shall be disproved by me using a fourfold argument. Primarily, establishing that the last seen theory that was relied upon by the trial court is completely unreliable in the given case. Subsequently, establishing that there was an absence of a sufficient motive on part of the accused to have killed the victim. Thirdly, that there was a non-fulfillment of the punch shield test, of the golden principle test, which is very imperative in the case of circumstantial evidences. And lastly, establishing that the police investigation that was conducted was very much faulty and thus unreliable in nature. Your Lordship, now moving on to the first limb of my argument, which is with respect to the last seen theory, that is the first circumstantial evidence. Your Lordship, as it was upheld in the case of Anjan Kumar versus State of Assam, the last seen theory, as the law itself is very clear on that, itself does not lead to an inference that the accused has committed the crime. Moreover, even when the last seen theory is proven, it does not directly lead to conviction until and unless it is corroborated with an incriminating evidence. And even if the last seen theory is independently proven in the absence of an incriminating evidence, all it does that it shifts the burden on accused to prove that how and when he departed the company of the deceased. Your Lordship, the last seen theory relies on two pillars. One, as I previously mentioned, being the time gap. Time gap, as in the given case, should be that the time gap between the duo, that is the accused and the deceased, being last seen together, and the time of the death of the deceased must be so small or must be so insignificant that there should be an impossibility of any third person other than the author, other than the accused being the author of the crime. Your Lordship, in the given case, what I would like to highlight before this honorable court is that there are no particulars of time, be it the testimony that is given by Miss Antonella and be it the testimony given by Mr. P in both paragraph number 12.4 of the moot proposition. Your Lordship, they do not give any particulars of time as to when they saw the duo together. Moreover, Your Lordship, assuming but not accepting that Mr. Chanston's testimony is reliable somehow, even Mr. Chanston did not give a particular of time as to when he saw the duo together. Your Lordship, furthermore, what is even surprising is that the post-mortem report, as mentioned in paragraph number 11.3 of the moot proposition. Are Your Lordships with me?
Yes.
Much okay. Your Lordship, even the post-mortem report states that the death occurred between a time gap of 12 to 2 a.m. Your Lordship, first of all, the time gap of 12 to 2 a.m. is itself a very large time gap. And coupled with the fact that there is no instance of the time that the duo was last seen together, and subsequently there is not even a particular instance of time of the death, the time gap between the two cannot be sufficiently calculated in order to establish that it was so small or so meager that there was an impossibility of any third person of being the author of the crime. Your Lordship, what is all the more amusing in the given case is that the death occurred in a public place. In a public place, Your Lordship, in a public place, which clearly shows that there was a huge chance, there was a huge possibility of any third person being the perpetrator of the crime. Your Lordship, even for an instance, if you rely on Mr. Chanston's testimony, what can be reasonably inferred from the same is that Mr. Chanston also crossed the very same place where the duo was seen fighting together and the place from where the body was recovered, which clearly shows that there was public movement in that place. There were other people in that vicinity, which clearly shows that the possibility of any third person other than the accused being the author of the crime cannot be ruled out. Your Lordship, that brings me to my second pillar of the last seen theory, which is the corroborating evidence and incriminating evidence that corroborates the last seen theory. In the given case, Your Lordship, an incriminating evidence is very much absent. The only evidence that has been recovered is the cigarette packet. A cigarette packet that was in possession of Christo. Your Lordship, now that recovery of a cigarette packet leaves room for multiple explanation and multiple hypotheses. There is a high chance that Lionel could have given that cigarette packet to Christo as a gift. There's also a high chance, considering the fact that Lionel's parents were unaware of his smoking habit, that Lionel used to keep his cigarettes with Christo. So there are multiple other hypotheses that can be created around the recovery of that cigarette packet. And Your Lordships, in a case of circumstantial evidence, where multiple hypotheses can originate that indicate towards the innocence of the accused, that circumstantial evidences cannot be considered to be conclusive in nature. And therefore, the recovery of this cigarette packet is not an incriminating evidence against them. Your Lordship, thereby the two pillars of the last seen theory have not been met in the given case. And therefore, the last seen theory is completely unreliable. However, Your Lordship, assuming, as an arguendo, assuming but not accepting that the last seen theory is somehow established, all it does, as I previously stated, is that it shifts the burden on accused to prove how and when he departed from the company of the deceased. Your Lordship, for the convenience of this honorable court, I would like to quote a landmark judgment of State of Rajasthan versus Kashi Ram on this incident. The threshold of the justification that needs to be given by the accused is clearly defined in the paragraph number 23 of the judgment. I shall read it and I quote, if a person is last seen with the deceased, he must offer an explanation as to how and when he parted the company. He must furnish an explanation which appears to the court to be probable and satisfactory. If he does so, he must be held to have discharged his burden. Your Lordship, now the threshold of the justification that needs to be given by the accused in the given case is that it only needs to be probable and satisfactory in the eyes of the court. And as my Lordships may have it, on paragraph number 9 and subsequently on paragraph number 13 of the moot proposition, do I have your Lordship's kind attention? Much of it. Your Lordships, in paragraph number 9 and subsequently in paragraph number 13 of the moot proposition, Christo gave a very reasonable justification. He stated that first of all, Lionel insisted to walk back home after a heavy meal that they had had, and secondly, that he was running late for to go back home. Otherwise, the guard would have shut the main gate, and he would not have been able to enter his apartment. Your Lordship, this justification given by Christo in itself is a very reasonable justification. Therefore, Your Lordship, even if we assume for a moment that last seen theory was proven, the burden that was casted on Christo has been sufficiently discharged by him as per the threshold that was laid down by the apex court. Your Lordship, that brings me to my second limb of the argument, which is with respect to the absence of a sufficient motive. Your Lordship, it has been alleged in the given case that there are two elements that constitute the alleged motive. One is the feeling of jealousy that could have, or as my respondents would say, that has crept in due to the game of football. And second one being the friendly borrowings between the two of them. And I shall disprove both of them separately. Your Lordship, now moving on to the first element that could have constituted motive is the routine borrowing that used to happen between the two of them. I would like to redirect this honorable court's kind attention to paragraph number 2 and subsequently to paragraph number 4 of the moot proposition. And I shall even read it for this honorable court's convenience. Your Lordship, the last line of paragraph number 2 states that Christo assured that he will return the money at the earliest. And in paragraph number 4 as well, it has been written that Christo expressed his inability to do so and promised that he will return the money at the earliest, which clearly shows, as it would have been a case between any two friends where one would have lent money to other, that the other promised and accepted that it was a loan and not either a gift or a charity. And Christo was very well aware of the fact that he had to return the money. And what can be reasonably inferred from these two paragraphs is that Christo had the willingness to repay the money, and even Lionel was very much acknowledging of that fact. Your Lordship, now it would be very improbable in the given instance to say that there was any kind of animosity between the two of them due to these routine borrowings. And this can be reasonably inferred from the paragraph number 5 of the moot proposition. If your Lordships may kindly have it. Are your Lordships with me? Much obliged, Your Lordship. Your Lordship, from paragraph number 5 of the moot proposition, it can be reasonably inferred that the duo went out for a friendly dinner late at night at their favorite restaurant, which clearly shows that it was a part of their routine that they used to go out. So had there been any kind of animosity between the two of them, and for a matter such as finances, the duo would not have gone out for dinner. Lionel would have been reluctant to go out for dinner, and he would have clearly denied the idea of going out. However, the duo very well went out for a dinner and eventually even sought for a friendly smoke break. Now, Your Lordship, moving on to the second element that alleges the presence of motive in the given case is with respect to the feelings of jealousy or ill will on part of Christo due to his inability to play in the football team, or due to the circumstances and the dynamics of the team being such that he could not play and was often found benched. If Your Lordships are with me, in what can be reasonably inferred from paragraph number 3 of the moot proposition is that Lionel was the leading goal scorer of the team, which clearly shows that Lionel was the star of the team. And if for a moment, if we assume that Christo had even 1% of sportsmanship, it can be reasonably inferred that he would have acknowledged Lionel's abilities. It was not a fact that it was only and only based on coach's favoritism that Lionel was getting the chance to play. It was also due to his merit, Your Lordships. Therefore, whatever Christo's friends used to feel about Lionel being able to play and him not being able to does not give us an account of Christo's feeling towards Lionel's merits and Lionel's game and the dynamics of the team. Your Lordship, therefore, in the given case, since there is no concrete evidence on record or no concrete fact on record to prove that there was any kind of ill will or animosity between the two of them, there it cannot be stated that there existed a sufficient motive that could have later translated into an intention to commit a heinous crime such as murder, and that too of a very dear friend in the given case. Your Lordship, now that brings me to my penultimate argument, which is with respect to the fulfillment of the circumstantial evidence. However, Your Lordship, before moving to that, I would swiftly like to point out something that my worthy opponents have contended in their written submission, is the presence of an opportunity by virtue of application of Section 7 of the Evidence Act that my worthy opponents have contested. Your Lordship, it needs to be noted that Christo and Lionel were very fast friends. So between these two kinds of fast friends, there could have been multiple instances where Christo would have had the opportunity to kill Lionel. And even if for a moment we assume that in this instance Christo had the opportunity to kill Lionel, what I fail to understand, Your Lordship, is why would Christo first take out Lionel for a dinner, be seen by multiple people such as Miss Antonella, Mr. Peak, and then finally decide to commit a crime? If crime was something that he had premeditated, he would have initially asked for a smoke break, stopped in an isolated area, and killed Lionel. However, that was not the case, Your Lordship. It is very much probable in this instance to recognize and acknowledge that why would a person who has premeditated a crime would invite attention of so many people who could turn witness against him, which clearly shows that Christo was acting in good faith and he had no such premeditation in his mind. Your Lordship, now moving on to my penultimate submission, which is with respect to the circumstantial evidences not fulfilling the threshold of the golden principles or the punch shield test laid down by the apex court in the landmark judgment of Sharif, Birdiz and Sharda. Your Lordship, this five-fold test that was laid down, if I may give a gist of the same, is that the circumstances of the case and the evidences and the chain of evidences must be so complete and that it must point only and only towards the guilt of the accused and towards no other possible hypothesis. However, Your Lordship, in the given instance, the circumstances establishing the guilt are not complete, as primarily there are no specifications of time to prove the last seen theory, as I already established. Secondly, the state even conveniently dropped guard as a witness who could have been a material witness in the given case. Thirdly, Your Lordship, there was no eyewitness. Fourthly, there has been no recovery of murder weapon. And lastly, and most crucially, the only evidence that was recovered, that is the Lucky Strike cigarette packet, which is an imported cigarette packet, Your Lordship. And that, as I previously explained, leaves room for multiple hypotheses, just like Lionel could have previously gifted it to Christo or used to keep his cigarettes with Listo because he could not have shown it to his parents. So since there are multiple loopholes in these chain of circumstances and chain of evidences, it cannot be conclusively said that all of them coupled together point only and only towards the guilt of the accused in the given case. And therefore, Your Lordships, in such a case, the golden principles are not completely established, which thereby make the circumstantial evidences rather inadmissible in the given case. Your Lordship, that brings me to my final submission, which is indeed the shortest one. That is, the police investigation that was conducted in the given case is very much faulty in nature. Your Lordship, I must point out before this honorable court that the council is not at all trying to contend that the police investigation is inadmissible. All that we are questioning is the reliability of that police investigation. Your Lordship, my argument is based on two pillars. First is the non-conduction of test identification parade, and second is the absence of independent witness during the various recoveries that were made throughout the course of investigation. And as your Lordships already are well aware of the fact that even though test identification parade is not a mandatory practice and nor does it vitiate the proceedings of the prosecution, however, Your Lordship, it becomes mandatory, it becomes essential in certain cases, as it was upheld by the apex court very substantively in the case of Lal Singh versus State of Uttar Pradesh, and also in the case of Malkhan Singh versus State of Madhya Pradesh. And I shall quote that the value of test identification parade varies from case to case on the facts and circumstances. Where the witness had only a fleeting glimpse of the accused and no test identification parade was conducted, then that must be viewed very seriously. Your Lordship, in the given case, we are not relying upon the fact that no TIP was conducted for Miss Antelina and Mr. PK. We are only relying on the fact that no test identification was conducted for the testimony given by Mr. Chancellor, because that is one of the sole testimonies that is being relied upon by the prosecution in the given case. Your Lordship, why TIP becomes essential in the given case of Mr. Chancellor is that the gentleman was in a rush, and in a rush that to procure medicines, and that too for whom? For his own child. So for a person, Your Lordship, who is rushing to procure medicine for his child, he must have seen the duo in a fleeting glimpse, of course, because he had other priorities to look after. He had his child to look after, and to even if we, for instance, we think from a psyche of a person who is in that situation, it is very improbable that that person could have recognized very distinctly how the duo appeared to be and later identified them in court. Therefore, Your Lordship, even though Mr. Chancellor's testimony is admissible because he directly identified the accused in court, it is not as reliable as it should have been. The veracity of that identification is very much questionable in nature, Your Lordship, since no prior refreshment of memory or test identification parade was conducted. Your Lordship, I will swiftly move to my second sub issue, which is with respect to the absence of independent witnesses being present while the various recoveries were being made. If Your Lordships may have paragraph number 12.7 of the moot propositions. Are Your Lordships with me? Your Lordships, the investigating officer himself admitted that there were no independent witnesses which are necessary, which are necessary by virtue of application of section 104 of the CRPC. There were no independent witnesses while either the recovery of the dead body being made, while either the recovery of the cigarette packet was being made, while the arrest was being made. So all throughout the course of investigation, there were no independent witnesses present, which makes the investigation report in itself a little questionable. Your Lordship, what also needs to be noted is something that is mentioned in the initial lines of paragraph number 11, that a short investigation was conducted. Your Lordship, for a crime as heinous as murder, a short investigation in that too that has multiple procedural inaccuracies, the investigation itself becomes very questionable, and therefore my client in the given case shall be given the benefit of doubt, Your Lordship. If Your Lordships have no further questions, the council seeks permission to recite the prayer.
Can I, this question to both the speakers. Now, this is a case of circumstantial evidence completely, right? Now, in a circumstantial evidence, let's look at the links or the chain which completes it. Number one, that there are two aspects of motive. One being jealousy, the other being the fact that a loan has been given. And despite repeatedly asking for return of the loan, money is not paid. So there are two aspects. Followed by the fact that you are a friend, obviously you would not like to take your friend for committing the murder. You go there, you have a meal, you come back. Now, you are from a poor background compared to Lionel, who is from a much richer background. This leads to a fact that a cigarette packet, which is of your friend's brand and which is a imported cigarette packet, has been recovered from your room. And 106 Evidence Act mandates that you have to explain as to how you got the cigarette packet. Number three, that why should the chance witness deep or falsely identify you when he has no axe to grind against you? Right? And ultimately, the fact that the body is found just a few blocks from the place you were actually seen together. Now, in a circumstantial evidence, obviously, when these facts have been proved, is it necessary in a case of circumstantial evidence that you have to prove every fact for the chain to be complete? Or if the link between each chain is established, that is sufficient to bring home a case of murder?
Your Lordships, I may seek an extension to, if I may seek an extension to answer that question.
Yes.
Much obliged. Your Lordship, primarily establishing a little fact that the dead body was recovered a few blocks away from Lionel's home, not from the place where the duo allegedly stopped for a smoke break.
Sorry, there are just a few blocks away, sufficient for the boy to walk back to his house. So, last seen a few blocks away, with a body being recovered again near that spot. Two witnesses seeing that you are arguing in loud voice will come to the fact as to whether it can be grievance or provocation when we hear the state's argument. A hit on the head, straight hit on the head, coupled with the recovery of cigarette for which there is no explanation, and no motive to implicate you by the witnesses who have seen you, would that not cover the entire chain? Or your argument is that every link has to be proved beyond a reasonable doubt to bring home a case of murder and circumstantial evidence.
Your Lordship, primarily establishing what your Lordship rightly pointed out, that the body was recovered a few blocks away. And as my client has also stated specifically, your Lordship, that it was upon Lionel's request that he wanted to walk back home. And since he was a few blocks away, he could have conveniently walked back, as my Lordship rightly pointed out. So therefore, your Lordship, these two things coupled together give a certain amount of credibility to the justification that my client has given in the given case with respect to how and when he went away from the company of the deceased. Now coming to answer the question of your Lordship as to the place of recovery of dead body. Your Lordship, it becomes very much questionable. If a person has already premeditated murder, why would that person kill the deceased at a place so close to his house? It becomes all the more risky for him to commit an act there because there could have been people in surrounding. The person would have chosen a much distinct or a much more isolated spot than a public area a few blocks away. Therefore, your Lordship, it clearly shows that my client had no intention to commit the murder to begin with. And now, your Lordship, now coming to the question that your Lordship rightly posed with respect to the discovery of cigarette packet. Your Lordship, as I previously stated, that even though there is by virtue of application of section 106 of the Evidence Act, the onus is on the accused to give a justification with respect to the recovery of packet. Your Lordship, the recovery of packet in itself creates multiple other hypotheses. And as I previously stated, it is Lionel's parents were very much unaware about his smoking habit, as it can be reasonably inferred from paragraph number 6. So, your Lordship, as it can be reasonably presumed in the given case, Lionel must have used to keep his cigarette packets with Christo so that his parents do not get to know about his smoking habits. Therefore, your Lordship, the other hypotheses that can originate from the recovery in itself are sufficient enough to prove the innocence of my client in the given case. And therefore, your Lordship,
how do you get over the fact that you have been identified by persons who have no motive to implicate?
Pardon, your Lordship?
How do you get over the fact that you have been identified by witnesses who have no motive to implicate you? They are not interested witnesses.
Absolutely. Your Lordship, we are not questioning the identification done by Miss Antonella or Mr. Peak, who is the toll booth operator and the waitress at the butchery. Your Lordship, we are only questioning the veracity of the identification made by Mr. Chanston. Your Lordship, the very fact that we are making it is we are placing reliance on the apex court decision on Malkhan Singh versus State of MP, where the facts were similar, that there was a fleeting glimpse that was seen by the witness. In the given case, as your Lordship, even Mr. Chanston was in a rush. He was rushed to procure medicines for a child. We are not saying that he is lying or he has an ulterior motive to identify my client. All we are presenting before this honorable court is that Mr. there's a very high possibility that Mr. Chanston could have misidentified that person. There could have been, though not with a particular reason, but due to inaccuracies or the short period of time in which he got to see him, he could have misidentified my client. And for that sake, your Lordship, my client should not be convicted for a crime as heinous as murder.
So therefore, the next submission of the part on the part of the appellant is that there are so many chinks in the chain that the chain is not complete, leading to fact proving that the murder is established beyond reasonable doubt.
Precisely. And if I may add one more line to that, Your Lordship, with your due permission. Your Lordship, as I was stating the judgment of the apex court in Sharad, Birdich and Sharda, the nature of circumstantial evidences must be so and so that it must conclusively prove only one hypothesis, that is the guilt of the accused, and must negate any other hypothesis that proves that indicates towards innocence. In the given case of chain of events and evidences, Your Lordship, there are multiple other hypotheses. Therefore, the threshold of circumstantial evidence is not met.
Thank you.
Much
Learned counsel for the appellants, please tell us, according to the post-mortem report, the time of death is between 12 a.m. and 2 a.m., right? And this was a busy road. Was it busy even at that time of the night?
Your Lordship, we are not contending that it was a busy road. As the facts clearly mention, it was an isolated area. However, the very fact that
there was sufficient footfall, the fact that Mr. Sultan went by. So it was a busy area.
Precisely, Your Lordship.
I mean, sufficiently busy that somebody else could have been there.
Precisely, Your Lordship.
Right. That's good enough. Thank you.
Much obliged, Your Lordship. It was indeed an honor pleading before this honorable court.
Just
And if
before
Your
you
Lordships may.
Just before you go away, and I know you've been drilled enough. So, one last, you just now said that you're not doubting the testimony of the toll booth operator.
Indeed, Your Lordship. He very much saw them cross.
You stand by that submission?
Absolutely. Absolutely, Your Lordship, because there was a large course of event that followed after crossing the toll booth.
No, I'm not asking you that. I only asked you whether you just now submitted that you are not assailing the testimony of the toll booth.
Absolutely, Your Lordship. We are not questioning that.
Okay.
There's sufficient doubts. Good enough.
Much obliged. Your Lordship, if you may please this honorable court, may I recite the prayer?
Yes.
Much obliged, Your Lordship. Wherefore, in the lights of issues raised, authorities cited and arguments advanced, it is most humbly and respectfully requested that the Honorable High Court of 𝐿𝐷 be pleased to 1. Quash Christo's conviction made by the trial court and acquit him of all charges. 2. Hold that the essential ingredients under section 299 or 300 and section 201 of the First Penal Code have not been met in the present case. 3. Hold that the respondents have not been able to prove the charges under section 299 or 300 and 201 beyond reasonable doubt, and or pass any other order it may deem fit in the interest of justice, equity, and good conscience, all of which is most humbly and respectfully submitted. And for this act of kindness, the appellant shall duty bound forever pray. Much obliged, Your Lordships.
Thank you.
Thank you so much, Mr. Counsel. Thank you so much, judges. Judges, if we are satisfied, if the court is satisfied with the appellant side, shall we proceed with the respondent's arguments?
Please do.
Thank you so much, judges. Judges, please note that Speaker 1 of Team URN 1907 will present the arguments now. Madam Counsel, you may please begin with the submissions. Thank you.
Is the counsel clearly audible and visible?
Yes.
Much obliged. Honorable greetings to the bench. May it please the court. With the kind consent of your leadership, may the counsel address the bench collectively as Your Honor. Much obliged, Your Honor. The counsel is deeply honored to present respondent's case in the matter of Christo versus State. For the convenience of the judges, may the counsel proceed with the brief facts of this case, Your Honor. Much obliged, Your Honor. Your Honor, this case arises out of an appeal filed against the decision of the trial court of 𝐿𝐷 for convicting the appellant Christo for offences punishable under section 302 and 201 of the First Penal Code. Your Honor, this matter revolves around the sudden disappearance of Lionel, the deceased, on the night when he met Christo and the next day when his dead body was recovered by the police. In the police custody, Christo confessed about killing Lionel, and during the trial, based on the testimonies of the witnesses that indicated motive, the state's last seen argument, and the post-mortem report, the trial court convicted Christo. Counsel 1 will be dealing with issue 1, that whether the essential ingredients of section 299, 𝐷 300, and section 201 are met in the present case, and thereby my co-counsel will be dealing with issue 2, that whether beyond reasonable doubt has been proved by the state, and whether a fair legal procedure has been followed in this case. If there are no preliminary queries, may the counsel proceed with the submissions, Your Honor. Much obliged, Your Honor. On the outset, The council would like to attract bench's attention towards page 9 of the moot proposition. Are the judges with me, Your Honor? Much obliged, Your Honor. Your Honor, as mentioned in the appendix, that all the provisions of Swiss Penal Code 1860 are in perimetria with Indian Penal Code 1860, except section 299 and 300, such that if all the ingredients of section 299 are fulfilled, then the case automatically comes under section 300, provided none of the exceptions fall in the case. With this, Your Honor, the council will be moving to the first issue of this case, and the council will prove that all the ingredients of this section, that is section 299 and 300 and section 201, are met in the present case through two sub-issues. First sub-issue will be regarding the ingredients of section 299, 𝐻𝐸 300. Moving to the first submission, Your Honor, the first ingredient of section 299 is that there should be an act done on the behalf of the appellant. And for proving the same, the council would like to rely upon the ratio of Om Prakash versus Union of India 2015, which was recently reiterated in the case of Mudakappa versus State 2021. That an act comes under section 299 when a series of circumstances prove incriminating conduct on the part of the accused. The council will prove this series of circumstances showing incriminating conduct on the part of the appellant, that is Christo. Firstly, Your Honor, as mentioned in paragraph 5 of the proposition, that the appellant called the deceased at late night despite latter's reluctance. And in addition to this, Your Honor, despite the increasing crime rate in the state of Kildare, which is mentioned in paragraph 1 of the proposition. Secondly, Your Honor, he stopped in an isolated place where no one could see him, as is mentioned in paragraph 6, Your Honor. And secondly, Your Honor, he was as submitted by my honorable and worthy opponents, Your Lordship. Your Honor, it is to be noted that Christo was new to the state of Kildare, as is mentioned in paragraph 1 of the proposition. And that is why, Your Honor, the council would like here to submit that he was only accustomed with that particular area near Lionel's home, and that is why he very intelligently chose an isolated place, which created a perfect opportunity for him to kill Lionel, Your Honor, which is very relevant under section 7 of the Evidence Act. And thirdly, Your Honor, it is to be noted that he was the last person seen with the deceased, as per the testimonies of Miss Antonella as well as Mr. Pick. And both these witnesses, Your Honor, clearly identified Christo in the court. And Your Honor, that is why the onus of proof shifted on the appellant under section 11 and section 106 of the Evidence Act, that he was somewhere else during the incident, and that he was not able to give a plausible explanation as to what was the reason of his sudden disappearance from the crime scene. And as recently laid down in the case of 𝐂𝐨𝐻𝐸 versus State of Bihar, 2021, when a case is totally based on circumstantial evidence, then this particular non-giving of explanation under section 106 adds to the incriminating conduct of the accused, Your Honor. Thereby, based on the series of circumstances, Your Honor, and non-giving of explanation, the council is submitting that the first ingredient of section 299, 𝐻𝐸 300, is fulfilled in this case. May the council proceed with the second submission, Your Honor?
Please go ahead.
Much obliged, Your Honor. Your Honor, the second ingredient of this section is that there needs to be an intention to cause death. And according to the ratio in Ghaffar versus Queen Empress, which was reiterated in the case of Stalin versus State 2020, Your Honor, the intention can be inferred from motive, time and place of attack, nature of the attack, and nature of injuries. And the council will be relying on the same, which is present in this case, Your Honor. Firstly, Your Honor, please note that there existed loan between the accused and the deceased. And as per the ratio of Rakesh versus State of Punjab 2001, Your Honor, it is to be noted that existence of loan suffices to prove motive under section 8 of the Evidence Act, as was held in this case. Further, Your Honor, in addition to this, due to the presence of the deceased in their football team, Christo, the appellant, were repeatedly outshone in their football team, Your Honor, which added to the jealousy and the motive relevant under section 8. In addition to this, Your Honor, not only the motive has been proved in this case, Your Honor, it is to be noted that inviting the deceased at late night and taking him to an isolated place also created a perfect opportunity under Section 7, which is relevant to prove intention as time and place of attack is very relevant. Lastly, Your Honor, even the nature of the injuries which have been mentioned in the post-mortem report under para 11.3. Are the judges with me, Your Honor? Much obliged, Your Honor. Your Honor, the post-mortem report mentions that the nature of the injuries were blunt force injuries. And as laid down in various cases, when the nature of injuries are on the vital part, like head, as in the present case, Your Honor, then it is sufficient to prove the intention under Section 299. So, Your Honor, not only motive, but time and place of attack, nature of injuries, and nature of attack is also very relevant and proves the second ingredient of Section 299 in this case. May the counsel proceed with third submission, Your Honor? Much obliged, Your Honor. Your Honor, the third ingredient, that is knowledge, is also very well present in this case. As recently laid down in case of Nagal Bhushan versus State of Karnataka 2021, any reasonable person knows the consequences of his or her act. And as described in the postmortem report, Your Honor, death was caused due to blunt force injuries on the head, which any person would know. The counsel would also like this bench to take the judicial notice of this fact under Section 57 and 56 of the Evidence Act, Your Honor, that blunt force injuries can cause intracranial hemorrhage leading to death. And this has been established as a scientific knowledge fact, Your Honor, in various forensic reports, as well as in various cases, Your Honor, like XVIII versus State of Maharashtra 2010, Dibar Gagral versus State of Bihar 2004, that such type of injuries, that is blunt force injuries on head, are sufficient to cause death. Therefore, Your Honor, the third ingredient, knowledge, is also very well present in this case. With all the circumstantial evidence pointing towards the act, intention, and knowledge, Your Honor, all the three ingredients have been fulfilled in this case, and clearly the accused is punishable under Section 302. In addition to this, Your Honor, the counsel will prove that none of the exceptions to Section 300 under Frisk Penal Code are applicable in this case. Firstly, Your Honor, contrary to the contentions of the counsels for appellant, first exception is not applicable here, Your Honor, according to which a grave and sudden provocation needs to be given by the deceased, where grave denotes a provocation that makes the person lose his equity, and sudden denotes that it was quick and unanticipated. But in this case, Your Honor, the appellants have not been able to discharge their burden under Section 105 of the Evidence Act to prove that any grave or sudden provocation was given by the deceased, as neither any direct nor any circumstantial evidence is present in this case to prove the same. Secondly, Your Honor, the contentions made by my worthy opponent for the appellant side, Your Honor, regarding the exception 4 to Section 300 that they have written in their written submissions, it is also not established in this case, Your Honor, because as laid down in Sidharth versus State of Odisha, Your Honor, these exceptions refer not only to a sudden fight, but absence of premeditation, Your Honor, as well. And in the present case, premeditation can be easily derived from the conduct of the accused, because as the appellant has already submitted, Your Honor, there existed malice between the accused and the deceased regarding the existence of loan and jealousy. And as submitted in the first submission, Your Honor, appellant had accurately planned everything that night, from choosing the place, from choosing the time, Your Honor, and even he insisted deceased that night, Your Honor, even when he was reluctant to come. So, Your Honor, clearly premeditation is present in this case, and that is why this exception also does not benefit the accused in this case, Your Honor. Therefore, Your Honor, the appellant cannot be benefited under any of the exceptions of Section 300, making him punishable under Section 302. May the counsel proceed with the second sub-issue, Your Honor, regarding ingredients of Section 201. Much obliged, Your Honor. Your Honor, as laid down in the landmark case of Vijaya versus State of Maharashtra, the primary requirement of this section is that there should be a commission on offense, and the appellant should have the knowledge that an offense has been committed. Indeed, Your Honor, an offense has been committed in this case, because if we refer to the nature of the injuries in the case, Your Honor, Those injuries were present on the vital part like head, and they were blunt force injuries, indicating that the death was not natural or suicidal, rather it was totally homicidal, Your Honor. And further, the counsel will prove that the appellant had reasons to believe that an offense had been committed. Because, Your Honor, he had an intention to escape from legal penalty. And that is only why, Your Honor, he gave false information regarding his reason to leave early, because he wanted to run away from the suspicion of the investigating officer. Secondly, Your Honor, with the same intention, he even hid deceased pack of Lucky Strike, which were later recovered from appellant's chest, as is mentioned in paragraph 11.5, Your Honor. Are the judges with me, Your Honor? Much obliged, Your Honor. These facts clearly show that appellant had knowledge that an offense had been committed and that he wanted to escape from legal penalty. With this submission, Your Honor, the counsel will be moving to the second ingredient of section 201, which is the disappearance of evidence. Your Honor, as laid down in the case of Deepak versus State of Maharashtra 1995, if any step is taken by the accused for disappearance of evidence, then he is clearly liable under section 201. First of all, Your Honor, in the present case, appellant deliberately stopped in an area which had a ditch and stream nearby, making it easy for him for discarding the murder weapon as well as the dead body. Please note, Your Honor, that this particular ditch, as is mentioned in paragraph 8, was a few blocks before Lionel's home, and this was a similar spot to the place, Your Honor, where they had stopped for smoking. So, Your Honor, clearly the appellant had very well planned that where he would discard the dead body as well as a murder weapon. And the counsel would also like to address the fact here that though no murder weapon was procured in this case, Your Honor, because according to the ratio of Lakshmi versus State, as well as Mrityunjay Biswas versus Pranab alias Biswas 2013, even if a murder weapon is not recovered in a case based on circumstantial evidence, then also based on the other evidences proving the guilt of the accused cannot be acquitted under section 201. And the counsel will prove, Your Honor, that indeed some other incriminating circumstances were present in this case. Because, Your Honor, please note that the last act which was between the accused and the deceased was smoking. And the very imported cigarettes of the deceased, which were not locally available in that area, were found out by the police in Christo's chest, as is mentioned in paragraph 11.5. And Your Honor, as contended by my worthy opponents, even if we assume that Mr. Pep testimony that all the belongings appeared to be on his body, we cannot rely upon the same. Even if we assume that he wanted to hide all the cigarette packs from their parents, Your Honor, it is to be noted that they were imported cigarettes. And we cannot assume here that only one pack was with the Lionel, Your Honor, in his possession, Your Honor. And that is why if he really wanted to give and if he really wanted to hide those cigarette packs from their parents, then he must have given all the cigarette packs to Christo, which was not the case in the present case, Your Honor. And even if we rely on even if we don't rely on Mr. Pep's testimony, Your Honor, it also indicates that if all the belongings were not present on deceased body, then it must have been the very same cigarette pack which was used by the Lionel that night. This establishes, Your Honor, that accused disappeared the evidence related to the offense, which was the dead body, as well as the murder weapon, as well as the Lucky Strike pack of the deceased. The counsel seeks permission to proceed with the last submission, Your Honor. Much obliged, Your Honor. The last ingredient of this section is that false information needs to be given on behalf of the accused. And for proving the same, the counsel would like to rely upon the doctrine of Nelsonian blindness, which means willful blindness, such that the accused remains unaware, deliberately he remains blind to the consequences of his or her act. The counsel will like to rely upon this doctrine to prove that he gave false information to the police. He stated that he was in a rush to return home. But please note, Your Honor, that if this statement was true, he would have not invited the deceased at late night in the very first place if he really know that he may get late that night, Your Honor. In addition to this, we cannot ignore the fact that if he was really in a rush to return home, he further would not have suggested Lionel for the idea of smoking if he really know that he was getting late that night, Your Honor. This clearly shows, Your Honor, that the false plea has been taken by the appellant regarding his rush to return home, because he knew the consequences, but his act, Your Honor, shows a contrary conduct in his statement, Your Honor. Thus, with the intention to escape from legal penalty and knowledge of Lionel's death, accused disappeared the important evidence in this case and also gave false information to the police, which makes him liable under section 201 of the FIS Penal Code. If the judges have any questions, Your Honor, the counsel is here to answer.
The others were complete in the last.
Much obliged, Your Honor. It was a pleasure arguing before this honorable bench.
Thank you so much, Madam Counsel. Thank you so much, respected judges. Judges, can we now invite the second speaker of the respondents team to present the arguments?
Is the counsel clearly audible and visible?
Please go ahead.
Much obliged, Your Honor. Greetings to the honorable bench. The counsel seeks permission to proceed with issue 2.
Yes.
Much obliged, Your Honor. It should be noted that, Your Honor, that issue 2 deals with whether the trial court has correctly applied the applicable test of beyond reasonable doubt in the present case. Your Honor, the honorable trial court has correctly appreciated the evidence and facts of the case and rightly found the guilt of the accused, as the state has proved it beyond reasonable doubt. Your Honor, it should be noted that beyond reasonable doubt does not imply absolute evidence, but only a logical conclusion that it was the accused on whom the charges have been leveled. It was the accused who has caused the offense, as was held in the case of HP Administration versus Om Prakash, 1972 Supreme Court. Your Honor, on the onset, the counsel would like to state the fact that the present case does not have any eyewitnesses. It is totally based on circumstantial evidences. Thus, the fundamental principles that have been laid down by the Honorable Supreme Court in the case of Sharad Birdichan Sharda versus State of Maharashtra, 1984 Supreme Court becomes very important. The same principles have been reiterated in the recent case of Srinivas versus State of Uttar Pradesh, 2022. Your Honor, in these cases, the principle that was laid down regarding circumstantial evidence was that in a case that is based on circumstantial evidence, the circumstances should be so conclusive that they show only one hypothesis, that is the guilt of the accused, and a chain should be formed. On that note, Your Honor, the counsel would like to bring the kind attention of this bench to certain clinching facts in the present case. Firstly, Your Honor, it should be noted that as per para 9 of the moot proposition, Christo was in a rush to return home as his colony guard often shuts the main gate and he goes to sleep. Your Honor, if that were the case, then any prudent person would not invite his friend for a dinner late at night, even when his friend was reluctant to come, as is clearly mentioned under para 5 of the moot proposition. Further, Your Honor, it should be noted above that on appellant's suggestion, they even stopped for smoking at an isolated place, as is mentioned under para 6 of the moot proposition. Your Honor, now the counsel would like to proceed with last seen argument to further substantiate that the case is being proved beyond reasonable doubt. Your Honor, it should be noted that a case that is based on last seen argument, in that case, the time gap should be very less when the accused and deceased were seen together, and when the deceased was found dead should be so small that any third person being the perpetrator of crime becomes impossible. Your Honor, this principle was stated in the recent case of 𝐂𝐨𝐻𝐿 Mehto versus State of Bihar, 2021. Your Honor, it's humbly submitted that last seen theory has a very high evidentiary value, but it should be corroborated with other circumstantial evidence. And Your Honor, in the present case, the last seen theory is being corroborated with other circumstantial evidence. Firstly, Your Honor, it should be noted that Miss Antonella, who was the Bob's butchery worker, she confirmed seeing two boys. They have come for the dinner, as is mentioned under para 11, part 6, and para 12, part 4 of the moot proposition. Further, Your Honor, it should be noted the Mr. Pick, who was a toll booth operator, he confirmed seeing two boys en route to Lionel's home that night, as is mentioned under para 11, part 6 of the moot proposition. Further, Your Honor, coming to the deposition of Mr. 𝐶𝐿. Mr. 𝐶𝐿 saw two boys roughly of the same age
at the same spot where Lionel's body was found, as is mentioned under para 11, part 8 of the moot proposition. Your Honor, the learned counsel on the behalf of appellant have questioned the credibility of Mr. 𝐶𝐮𝐡𝐭, who happens to be a chance witness in the present case. Your Honor, it should be noted, the counsel acknowledges the fact that in the case of chance witness, the court needs to be a little, the courts needs to show a little more scrutiny as to how, as to why the person was there at that point of time. However, it should be noted that in the present case, Your Honor, Mr. 𝐶𝐮𝐡𝐭 had given enough reason as to why he was there, because his son was ill and he had to rush to medical store to get the medicines. Further, Your Honor, it should be noted that Mr. 𝐶𝐮𝐡𝐭 was present before the court and he identified Mr. Christo in the court as per the clarification number 21 given by the court. Further, Your Honor, it should be noted that no adverse inference could be drawn of the fact that no TIP was conducted in the present case, because TIP, it's not necessary that a TIP should be conducted. It could be withheld in a case where there is where the court identification has been taken place, as was held in many cases, such as Buddha versus State of Uttar Pradesh 1970. Your Honor, coming to the next corroborating piece of evidence, it should be noted that Lionel and Christo stopped for smoking at an isolated place few blocks before Lionel's house, as is mentioned under para 6 of the moot proposition. And at the place of the same description, police recovered a body. It says a ditch that was there at the isolated roadside area few blocks before Lionel's home, which means which is mentioned under para 8 of the moot proposition. Further, Your Honor, one of the most important and the prime corroborative piece of evidence is the ballistic evidence. Your Honor, it should be noted that as per post-mortem report, as is mentioned under para 11 part 3 of the moot proposition. Are the judges with me? Yeah. Much obliged, Your Honor. The death was caused after being hit on head with a blunt object. And Your Honor, in many forensic reports and in the case of SK Sattar versus State of Maharashtra 2010, it was held that blunt object consists of heavy stone as well. Your Honor, blunt force injury can cause hemorrhage leading to death, as was caused in the present case. Coming further, Your Honor, there's a presumption when the last seen theory is corroborated with other circumstantial evidence. There's a presumption that it was the accused who could have caused the offense. Your Honor, in the present case also, since it is being corroborated, the last seen theory is being corroborated with other circumstantial evidence, there creates a presumption. However, the counsel acknowledges that these presumptions are rebuttable one. And the first way of rebuttal is to show separation from the deceased before the incident took place. Your Honor, it should be noted that the Honorable Court in many cases such as Ravinder versus State, NCT of Delhi 2019 said that if the person is last seen with the deceased, he must offer as an explanation as to why, as to when he parted his ways with the deceased. Because as per section 106 of the Evidence Act, he would have the special knowledge as to how he parted ways and when he parted ways. Your Honor, it should be noted that in the instantaneous case, the appellant was not able to give any hypothesis of his sudden disappearance. Further, Your Honor, it should be noted that the second way of rebuttal is third-party intervention. However, it is not applicable in the present case because as per para 1 of the moot proposition, it was night time and the population of the state of Kildare was very small. So since there have been testimonies which suggest that the two boys were there on that night at that point of time, so it suggests that it was only those two people who would be there. Further, Your Honor, it should be noted that Mr. 𝐶𝐮𝐡𝐭 was there only. Mr. 𝐶𝐮𝐡𝐭, who was a chance witness, was only there because he had to rush to medical store to get medicines. Thus, there was an emergency and that's why he was present late at night. Otherwise, there were no people there on that late night. Further, Your Honor, the third way of rebuttal is physical inability, and that is not applicable in the present case. Your Honor, the counsel would now like to bring forward certain relevant facts which are very essential in a case that is based on circumstantial evidence. The first one being presence of motive. Your Honor, it is duly submitted that motive is relevant under Section 8 of the Evidence Act. And Honorable Supreme Court in many cases and reiterated in the recent case of Shivaji Chintappa Patil versus State of Maharashtra 2021 that motive is not so important in a case that is based on direct evidence, that is eyewitnesses are present, but it becomes very, very important in a case that is based on circumstantial evidence. Your Honor, the counsels on the behalf of appellant have contended that there is no direct proof of motive in this present case. However, Your Honor, it should be noted that motive, we cannot read the minds of people, and relevant facts such as motive is inferred from the circumstances of the case. And in the present case, there are enough circumstances which suggest that there was motive on the part of appellant. Firstly, Your Honor, please refer to para 9, page 3 of the moot proposition, and subsequently para 2, page 1 of the moot proposition. And as per this, the deposition of Mr. 𝐿𝐻 and Mr. 𝐿𝐻𝐿 suggests that Lionel used to lend money to Christo, not occasionally, Your Honor, but for daily expenses. Thus, it would have created a very high debt on the part of appellant. Further, Your Honor, it should be noted that there have been cases where it was held that debt or loan could be considered to be a sufficient motive, such as in the case of Ravinder Kumar versus State of Punjab 2001. Further, Your Honor, it should be noted that coach used to favor Lionel as he considered him to be a better player, as is mentioned in the para 12 of the moot proposition. And Your Honor, in many cases, it has been seen that jealousy and enviousness could be a reason for committing such a grievous offense, such as in the case of Satish Babu and others versus State of Uttar Pradesh. Your Honor, the council would also like to bring upon the fact that that the councils on the behalf of appellant have alleged that there was no sufficient motive. However, it should be noted, Your Honor, that there have been many cases where it has been conclusively held that gravity of offense need not balance with the reason of committing that. And there was a precautionary note that was given by Lord Chief Campbell in the case of R versus Palmer, which was quoted in the case of HP versus 𝐂𝐸𝐻 1999. Thus, even if the counsels on the behalf of appellant contends that there was no adequate motive, it should be noted that it's not necessary that the gravity of the offense should balance with the adequacy of motive. Further, Your Honor, it should be noted, coming to the next relevant fact, which is opportunity and occasion, which is relevant under Section 7 of Evidence Act. Your Honor, it should be noted occasion refers to the circumstance or the set of circumstance in which the incident took place. And Your Honor, opportunity is created out of the occasion. While mere opportunity is not considered to be so important, but exclusive opportunity becomes very important. Your Honor, in the present case, acceding to go for dinner created a mere opportunity, but stopping for smoking at an isolated place created an exclusive opportunity for the commission of offense. Your Honor, the council now seeks permission to proceed with the third issue regarding fair legal procedure. Much obliged, Your Honor. Your Honor, the council will substantiate this argument with the help of two arguments. Firstly, all stages of investigation and trial was in consonance with Article 21. And secondly, no adverse inference could be drawn of certain incriminating facts which are present in the present case. Your Honor, in the instant case, starting from the afternoon that they received an information regarding a missing boy, the very evening the police had recovered a body. Subsequently, by virtue of Section 161, Clause 1 of Criminal Procedure Code, the police inquired all the potential people who could be acquainted with the facts, such as guard, the common friends, Christo, etc. Thus, there was no delay in recording the statement. Following that, Christo was arrested for the offense under Section 302 and 201. Police filed the investigation report, following which the Honorable Trial Court framed the charges as sufficient ground existed in the present case. Further, Your Honor, the appellant pleaded not guilty. As a result, trial had begun. The prosecution and defense evidence was recorded. Further, by virtue of Section 313 of Criminal Procedure Code, the statement of defense was also recorded by the Honorable Court. Your Honor, it should be noted at this point of time that defense did not produce any evidence on behalf of them. Further, Your Honor, thus the whole process was in consonance with Article 21. Your Honor, proceeding with the second sub-issue in this particular issue, it says that the council acknowledges that there are certain incriminating facts in the present case. However, no adverse inference could be drawn because of the following reasons. Firstly, talking about non-recovery of murder weapon. Your Honor, it is well-established principle laid down in various cases such as Dinesh Kumar Kalidas versus State of Gujarat 2018 that mere non-recovery of murder weapon will not topple the case if there is other cogent and clinching evidence present. And that is why the Honorable Trial Court did not take any adverse inference of the fact that murder weapon could not be found. Moreover, Your Honor, it should be noted that that murder weapon was discarded in a ditch, and that is why it could not be found. Further, Your Honor, it should be noted the absence of independent witness also requires no adverse inference in the present case. Your Honor, as the council acknowledges that as per section 100 clause 4 and 5 of Criminal Procedure Code, there's a need that at least 2 or more persons of either same locality or some other locality should be present while preparing the discovery memo. However, Your Honor, it should be noted that this is not a rule that is inflexible in nature. In many cases, there has been observations, such as in the case of Appa Bhai and another versus State of Gujarat, 1988, that civilized people are generally insensitive to crime, and they shun away from giving attesting the memos. And further, Your Honor, it should be noted that in the present case, due to night time, no person could be found. Kildare being a very small state, it is quite probable that no person would be present at that point of time. Further, going to the last incriminating circumstance in the present case is, Your Honor, there was a failure to call guard as a state witness. Your Honor, but it should be noted that the basic rule is that only those person needs to be called as a witness which are material or which are important for unfolding the narrative of the case. Your Honor, the council, it should be noted that in the case of Swaran Singh versus State of Punjab 1976, which is recently cited in the case of Rajesh Yadav versus State of Uttar Pradesh 2022, that before Your Honor, that mere eyewitnesses who had actually seen the occurrence and were material to prove the fact, only those people are called material witness, and no adverse inference could be taken of that fact if they are not the one who as stated in the case. Your Honor, the guard, Your Honor, the state did not believe him to be a material witness, and that is why he was withheld as a state witness. Further, Your Honor, it is to bring to your kind notice that defense could have brought him as a witness for themselves if they found that he was material in proving their case. Thus, Your Honor, that's all. The council will finally submit that in the present case, all complete chain is being formed. Called, it was an isolated place. Further, Your Honor, Miss Antonella, Mr. Pick, Mr. Sultan, they all deposed that the two boys were there on that night. Further, Your Honor, the last seen theory was in corroboration with other circumstantial evidence, and Your Honor, it should be noted the relevant facts such as motive, occasion, opportunity have been established in the present case. Further, Your Honor, the certain incriminating facts were there, but there are explanations to it, and no adverse inference should be taken of those. Thus, the council believes that it was a grave offense that was committed. It was not a wrong, not only on for the deceased, but whole society, whole state of Kildare, and the court should take into consideration. You know, that's it. That's all. The council rests the case, and if there are any questions, the council is here to answer.
For the state, you have not adverted to the submission made by council number 1 for the appellant. That could it not be a case of grievance and provocation?
Your Honor, the council number 1 on the behalf of the respondent have addressed that it was not a case of grave and sudden provocation. Right. Your Honor, it should be noted that there are no facts which shows that there was sudden provocation on the part of on the part of Christo, because it should be taken into consideration, Your Honor, that he very well planned the fact, because he asked his friend to come for dinner at late at night, even when his friend was reluctant to come. And further, Your Honor, he suggested to stop for smoking at an isolated place, and it was Christo's suggestion. It shows that he had actually planned all the things.
No,
There was
just
no
a
sudden
suggestion for the state, that his case of complete denial. So when it is a case of complete denial, where is the question of grievance and provocation? For him, nothing happened. There was probably an altercation. That's about it. So when it's a case of complete denial, where is the question of grievance and provocation at all? When after the proceeding is over, when a question is asked to defense the 313 statement, his answer, obviously, as the memo proceeds, is that he pleaded not guilty and asked for a trial. Grievance and provocation would come only when he says, yes, we had a fight and I got angry and I hit him. Then, so therefore, that's once again. Now, now the second is, of course, that failure of investigation. In a case of circumstantial evidence, a chance witness, obviously, when you file your charge sheet, the name of the chance witness is there.
Indeed.
Now, not having a TIP parade for a chance witness, will that not be fatal for the case of the prosecution? Because by the time the evidence takes place in court, the chances of the witnesses being identified is much greater. So in a case of circumstantial evidence, would not such a thing be fatal? And whether such a lapse should inure to the accused or not?
Your Honor, the counsel begs to differ on this point. It should not be fatal in the present case, because first of all, there was court identification that took place Further, Your Honor, it should be noted that Christo was a very new person in the state of Kildare. There is no chance that he would be having any animosity with any person, and that is why a chance witness, that is Mr. Chancellor, had no reason why he would put an innocent boy in for such a grievous offense. And yeah,
I understood that there was no reason to implicate him unnecessarily. And then lastly, on your 27 disclosure, you say that of course we've discussed. Now the dead body that is found. Now dead body has been found. The accused points the finger at the place where the body is found, which you have taken as an important circumstance for the 27. Now, it's a place where others had already identified the witness or identified the body, because the body had been found before that. The place had been identified. In such a case, would that 27 be of any consequence, pointing towards the complicity of the accused?
Your Honor, the counsel acknowledges the fact that body was recovered before the procedure of section 27 was done in the present case. However, Your Honor, it should be noted that if we the testimonies that have been given in police custody, they cannot be discarded totally if there is a corroboration, as was held in many cases, such as, just a second, Your Honor. Your Honor, in the case of Sahadevan versus State of Tamil Nadu, 2012, it was stated, it was said that the confessions that have been made in police custody, they cannot be totally discarded if there were 5 principles that were laid down. The first and the most important one was that that it is supported by the chain of cogent circumstances and corroborated by other prosecution evidences. Your Honor, it should be noted that here the 3 prosecution witness, namely Mr. Chancellor, Miss Antonella, Mr. Pick, they corroborated to the fact that they saw 2 boys. Further, Your Honor, post-mortem report also confirmed the fact that a blunt object, and stone is a blunt object which could cause hemorrhage and cause death. So hence the statements that were given in police custody were corroborated with the other prosecution witness and evidences. Even though section 27 does not the statements of confessions are not admissible or cannot be proved, but due to this case and due to these circumstances, it should be taken into consideration.
Thank you.
Much
If I
obliged.
may, no, either of the speakers could answer this question. Now, the state has sought to discount the statement of the accused that he had to rush back home, otherwise the colony gate would be shut down. He would not be able to enter. Your case is, no, that's doubtful. It could never happen because there was another small gate through which he could have gone. Was this fact ever established? Because two things are established here. The dead body is there. There is a post-mortem report. Those two things are essential. The very important element when you start doubting him is, has the height of the gate been established? Was there a small gate through which a motorcycle could have gone? You never called the guard for cross-examination. That's a major chink in the prosecution case. How can you discount this person's the accused statement of the accused? Suppose there is a gate through which there was the motorcycle could not go back, could not go through. She'll have to believe his statement. I had to rush back home. Maybe his motorcycle was very large; it could not go through. So in your procedure, there is a flaw. That's one. Two, about the jealousy. They were friends. How much time ago were they in the university? They were all sports persons. One was a good top scorer and the other guy was a player. But this is just to build up a story. Should we start doubting him and impute motives to him because they were football players? These are two elements I thought that maybe the state would have to prove a little more. The most important thing about your procedure is two things you brought forth is the body and the post-mortem report. What about the gate? What about the guard? Nothing established, right? You may want to dwell upon that.
Thank you for the question, Your Honor. Your Honor, coming to the first question that was put regarding the guard who was withheld as a state witness, it should be noted, Your Honor, that the state did not find him to be a material witness because firstly, he had not seen the person come at what point of time the person was coming, the Christo was coming, and further, Your Honor, it was inferred it could be inferred that a false plea was taken by Mr. Christo because of the fact that had he not been in rush, then he won't have called his friend for dinner late at night and even stopped for smoking at an isolated place when it was more late. So from this inference, it could be drawn that a false plea was taken, and that is the one of the way to rebut last seen theory. And since the false plea was taken, and the counts so the onus was on the appellants to prove as to how he parted ways as per section 106 of the Evidence Act, and that is why the state did not find him to be a material witness. Secondly, Your Honor, coming to jealousy, it should be noted that there are many instances which shows that there was jealousy on the part of appellant towards the Lionel, because he himself was a very good player in his previous school or college, previous school, as is mentioned under para 3 of the moot proposition. Further, Your Honor, there have been cases where it was held that jealousy and enviousness could be sufficient and to cause such a grievous offense, such as Satish Babu and others versus State of UP, Krishna Swaroop and another versus State of UP 2020, etc.
Right. Thank you.
Much obliged, Your Honor. Your Honor, if the judge permits, can I please cite the prayer?
You do.
Much obliged. Wherefore, in the light of the issues raised, arguments advanced, and the authorities cited, it's humbly prayed that to this honorable court that to declare that all the ingredients of section 299, 300 and 201 of Frisk Penal Code 1860 are fulfilled, to uphold the decision of Honorable Trial Court in Kildare, as the state has successfully proved the indictment against the appellant beyond all reasonable doubt, and to declare that a fair and equitable procedure, it was in consonance with Article 21 of the Frisk Constitution 1950 has been followed, and to pass any other order, direction and relief which this honorable court deems fit in the light of in the interest of justice, equity, and good conscience. Thank you.
Thank you. Arguments
you.
heard, judgment reserved.
Thank you so much, Madam Counsel. Thank you so much, judges. Judges, I'd like to inform the courtroom that the appellants have reserved 2 minutes for the rebuttal. So if your worthy judges permit, can they move forward with the same?
Go ahead.
Thank you, judges. I request the appellants team to please take the rebuttal.
Your Lordship, speaker number 2 on part of the appellants will be taking the rebuttal. The first rebuttal being the one that the Honorable Court has rightly mentioned is with respect to the justification given by Christo not being disputed by the worthy opponents. Your Lordship, all they have done is to rely on the statement of guard. The statement of guard, Your Lordship, can be clearly seen in paragraph number 9 of the moot proposition. My learned from speaker number 2 from the opponent side stated that guard did not see Christo come back home. However, amusingly, guard never gave an account of whether he saw Christo or not. All he told that there was a separate gate. Your Lordship, this was first of all a 161 statement, which is not admissible. Secondly, this statement was never even brought on 173 investigation report. Thirdly, the guard was never even brought before the court. So it becomes all the more questionable as to how the veracity of this testimony is being determined. Secondly, Your Lordship, the court, my worthy opponents, have relied their case of section 201 on the murder weapon being destroyed and thrown in the stream. However, Your Lordship, as I may refresh the memory of this honorable court and that of my worthy opponents as well, that the only instance of murder weapon mentioned in the entire moot proposition is the one that is in the confession. And by application of section 25 of the Evidence Act, the confession is very much inadmissible. So we don't even know if it was a stone that was hit on his head, if it was a rod which was hit on his head. We don't even know the accounts that followed. And Your Lordship, as it was held in the case of 𝐻𝐿𝐻 versus State of Rajasthan by the Apex Court, in a case where the weapon has not been recovered, the charge under section 201 cannot be leveled unless it is conclusively proven that accused destroyed the weapon. Your Lordship, now here, first of all, neither the weapon has been recovered. Secondly, it cannot even be proven that the accused has destroyed the weapon because it forms a part of confession, which is inadmissible. Your Lordship, which takes me to my third argument, which is with respect to the motive. Your Lordship, could I please seek an extension of 2 minutes if you may graciously permit? Very much of it. Your Lordship, my worthy opponents have placed lines on the fact there was no sufficient motive on part of Christo. However, Your Lordship, there was sufficient motive on part of this. Sorry. However, what was held in the case of Sampath Kumar versus versus Inspector of Police was that motive cannot lead to conviction when chain of circumstances are not complete, which, as I previously established, are not complete in the given case. Your Lordship, my worthy opponents have placed the large part of the reliance upon the jealousy that existed between the duo. Your Lordship, now, as I must reiterate, this jealousy has allegedly crept into football game, which needs to be noted that a game of football has 11 players, and jealousy is a very common human emotion. And it cannot be said that that Christo was only jealous because of Lionel. So, if we go by the theory given by the respondents, then right now Christo would have been planning the murder of all the 11 people who are playing in the team, because it cannot be conclusively proven that it was only Lionel because of whom Christopher did not get the opportunity to play. And lastly and most importantly, Your Lordship, my worthy opponents have continuously placed reliance upon the fact that there was a lot of premeditation and thought that went behind this murder. Christo was very well aware of the place. Christo very well identified the place that had a narrow ditch and was isolated in nature. But what is rather amusing is a person who has put so much thought into it, why would that person take his friend to a butchery, have a dinner, come back late at night, stop for a smoke break, and be identified by so many people? Could this not have been done at the very first instant they went out of their house? So inviting so much attention in the light of the fact that there was premeditation is rather questionable, Your Lordship. And lastly, Your Lordship, there are many missing links. The non-recovery or non-identification of the murder weapon is very much questionable in nature, and it was held in the Sanjay Biswas versus Pranav. It was held that this case has held that non-recovery of murder weapon does not affect the prosecution case, where there is an ample, unimpeachable ocular evidence corroborated by medical evidence, which is absent in our case, Your Lordship. Your Lordship, that is all from the side of the appellants. the council was humbled to honor or to plead before this honorable court.
Thank you.
Thank you so much, judges. Thank you so much, Mr. Counsel.
Just for pronouncement, 20 minutes later.
So, Justice Bhat also joined. We'll request him to hold on for another 10-15 minutes. Can we request the judges to join the other link? Sir, sorry, Justice Bhat, we made you join a little earlier than we had planned. Apologies for that. Sir, you're muted.
I'll join 10 minutes later.
Right. So we'll have to log off now.
Your Lordship, we've emailed the link for the scoring meeting to you.
We'll have to log off from here.
To your email ID. Yes, sir. You can log off from here and join the other meeting. We've just sent it at around 12 o'clock, sir. Where the three lordships can confer confidentially to assess the participants.
Thank you.
My apologies, Justice Bhat. Can we request you to come back in 10 minutes?
So should I leave or should I be here and mute myself?
No, sir, you can mute yourself. Put the camera off. We'll let you know in 10 minutes, sir.
Okay, right.
Thanks. We'll join back in 10 minutes for the prize distribution ceremony on this link as well itself.
All right, sir. Noted. Thank you so much.
Can't get on. We should say like.
Justice Waziri, I've sent you a message with the details.
I'll just,
I've sent it to Justice Verma as well, as also to Justice Prasad. Sir, we'll send you the details of the announcements you'll have to make. That we'll send to your PS, or I can send it to you on the mobile.
You could do that.
Just send it to us, Sidharth, please.
Ani, aapko maine bhej diya hai. Just see if you got it or not on your phone. SMS.
Oh, SMS.
I message aapko.
I got something for the Aradhana Swan.
Oh, just a minute. That's the name. That's the name. That's the name. The award, the amount, and the person's name is below that.
So that's what I have to say, is it?
Yeah. We'll let you know. We'll prompt you at the appropriate stage.
Unless we forget by the time we reach there.
We'll just send it to that as well in a moment, sir. I think if Justice Prasad is joined, then we can start.
But first, serve and speak.
We'll go as per schedule, sir. First, there will be an introduction by Harleen, a short speech by Alka, then serve and speak. And just should we, Harleen?
Yes, sir.
We start, sir? If Justice Verma has joined, if Justice Prasad just joins, we can start immediately. I'll just call.
Good afternoon, sir.
Good afternoon.
Good afternoon, sir.
Good afternoon.
Good afternoon, sir.
Good afternoon.
Right.
So, आपने मुझे Justice Verma, I'm just going to call you and get the details of the result. I'll have to just call you and get the.
Hello. Yes, sir. बोल रहा हूँ, sir. Sir, I'm in a meeting. Can I call you sometime?
Sidharth here is 1876 is on.
Okay, sir. I think we can, Harleen, we can start, sir. Justice Bhat, I'll send you the. I'll send the details. Justice Harleen, would you like to start?
Madhav, so I think Madhav would be starting the same.
Good afternoon, everybody, and a very, very warm welcome to the prize distribution ceremony of the 18th K.K. Luthra Memorial Moot Court 2022. We are extremely honored to have amongst us Justice Ravinder Bhat, Judge of the Supreme Court of India, as the chief guest, and Justice Najmi Waziri, Justice Yashwant Verma, and Justice Subramanian Prasad, judges of the Delhi High Court, as the guests of honor. Now, all that is left for me to do is invite Dr. Harleen Kaur, teacher convener of the Moot Court Society of Campus Law Center, to give an introduction to the event.
Thank you so much, Madhav. Warm greetings to our chief guest for the event, Honorable Mr. Justice S. Ravinder Bhat, Judge Supreme Court of India. Our guests of honor, Honorable Mr. Justice 𝐂𝐻𝐿𝐻𝐵𝐻, Judge Delhi High Court. Honorable Mr. Justice 𝐑𝐻𝐿𝐻𝐵𝐻 Verma, Judge Delhi High Court. Honorable Mr. Justice 𝐬𝐵𝐻𝐿𝐻 Prasad, Judge Delhi High Court. Respected Professor in Charge, Campus Law Center, Professor Dr. Alka Chawla. Respected Mr. Sidharth Luthra, former ASG and senior advocate. Distinguished guests, respected delegates, guilty members, and dear participants. I welcome you all to this prize distribution ceremony of 18th edition of K.K. Luthra Memorial Moot Court 2022. We are indeed thankful to our honorable chief guest and honorable guests of the honor for having graced the occasion. It gives me immense pleasure to introduce this august audience to the most sought after international criminal law moot competition and the flagship event of the Campus Law Center. Since its inception in the year 2005, this competition is being organized every year in the memory of Shri K.K. Luthra, senior advocate, a leading lawyer in the field of criminal law without fail, with an endeavor to provide a platform to the budding law graduates to hone the art of advocacy based on facts and calibrated arguments in gracious presence of honorable sitting High Court judges and other leading stalwarts of the country. I really take pride in saying that amidst this global crisis, which we have been witnessing for the last 2 years, we have also shifted to virtual transformation in furtherance of our commitment. And like previous year virtual edition, this year too, this event spanned across all 5 continents, witnessing registration from more than 100 teams, out of which 66 teams from 9 countries qualified for the oral rounds. The entire event spanned over 7 days, and after 5 layers of rigorous adjudication, including the prelims, the octafinals, the quarters, and the semis, today we have witnessed the final 2 teams presenting their case in the presence of our guests of honors, who have been gracious enough to judge the final rounds. It was only under the able guidance of Professor Dr. Alka Chawla, Professor in Charge, Campus Law Center, who herself is a source of great inspiration to the entire CLC. Ma'am, from being recognized in top 100 powerful women in law in the list released by the World IP Forum in 2017, and again in 2021, has been the recipient of various awards, author of books on copyright law, and has been a resource person to many national and international universities of eminent prestige. It was also with the tremendous support from Mr. Sidharth Luthra and their officials that our dedicated team of students, headed by Mr. Madhav, along with the teachers of the Moot Court Society, coupled with the technical support from the promoters, ensured the smooth execution of the competition and made this event the most cherishable event for all the participants. On this note, I would like to thank Mr. Sidharth Luthra for such an endeavor and congratulate Sir and his family for adding another feather of successful organization, and would really look forward to the next grand edition of this event. I would also like to thank everyone for gracing us with your presence. Thank you so much.
Thank you, ma'am. Now I would like to invite Professor Dr. Alka Chawla, Professor in Charge of Campus Law Center, Faculty of Law, University of Delhi, to introduce our guests of honor, the judges from the Delhi High Court, as well as our Honorable Chief Guest, Honorable Mr. Justice S. Ravinder Bhat. Ma'am.
Thank you, Madhav. Thank you, Dr. Harleen. Respected Chief Guest, Honorable Mr. Justice S. Ravinder Bhat. Guests of honor, Honorable Mr. Justice Najmi Waziri, Honorable Mr. Justice Yashwant Verma, and Honorable Mr. Justice Subramaniam Prasad. Mr. Sidharth Luthra, his family associates, faculty members, dear students and participants, ladies and gentlemen, a very, very good afternoon to all of you. Campus Law Center, as you all know, since its inception in 1924, has been a leader in producing legal luminaries, some of whom are sitting right here in front of me, though on the monitor. Supreme Court and High Court judges, leading advocates, political leaders, policy makers, and trendsetters in all walks of life. It is endowed with elitist alumni, even though it is an egalitarian institute, providing legal education at a negligible cost. The characteristic mark of any subliminal educational institution is evidenced by the methodology it adopts to teach its students how to interact with the professional world that awaits them once they are outside the benign institution. Moot courts are the golden arrow in the quiver of law schools such as ours to effectuate the responsibility of acquainting its students with the practical side of practice of law. In this endeavor, it is undoubted that the K.K. Luthra Moot Court competition is the flagship event not only for the Moot Court Society, but for the entire Campus Law Center. The K.K. Luthra Moot Court competition was started in 2005, as you all know, in the memory of late senior advocate Mr. K.K. Luthra. The competition was instituted and organized by Mrs. Nirmala Luthra, and after her demise in January 2020, her family is continuing with the competition. Nirmala auntie, we remember you very fondly. Your life was an inspiration for all of us and the entire Luthra family. In 2005, there were 16 institutions nationally who participated, and just in 4 years, it became an international event and saw participation from over 40 institutions, and now we can't even count, we have to limit to a certain number. The last 6 editions of competition have seen participation from over 60 universities, including Cambridge, Northumbria, Warwick, George Washington, Singapore, Pakistan, Sri Lanka, Nairobi, and so on and so forth. This year's competition saw spirited arguments over the course of this past week for 7 days on issues surrounding murder, circumstantial evidence, and the last seen theory. Arguments were not only well thought out and structured, but were delivered zealously, as is expected from young, budding lawyers. I'm sure that each and every participant in this year's competition will go on to leave an indelible mark on the legal profession. We would have been delighted to host you on our campus for this edition of the competition, but we are glad that we were able to host you virtually at least and organize a successful competition. Despite the postponement due to Omicron variant of COVID-19, I wish and I hope and I pray on behalf of the entire organizing committee that the 19th edition would be held physically at Campus Law Center. It is my proud privilege to introduce one of the most erudite, respected, soft-spoken, loved by youngsters, a very, very dear friend of the family, Judge Supreme Court of India, Justice S. Ravinder Bhat. Justice Bhat studied English at Hindu College, Delhi University, law at Campus Law Center, got enrolled as an advocate with the Delhi Bar Council in 1982, and practiced before the Supreme Court, where he was enrolled as an advocate on record. He got elevated as a judge of the Delhi High Court in 2004. In May 2019, he was elevated as the Chief Justice of the Rajasthan High Court. And I remember when his oath ceremony was to take place, I think the entire bar and the bench drove down to Jaipur to witness their loved one's elevation. That's what Justice Ravinder Bhat stands for. Thereafter, he was elevated as Judge of the Supreme Court of India in 2019. Justice Bhat is known for his renowned judgments in almost all fields of law. He has played a great role, in fact, in building the IP jurisprudence in the country, of which I am very interested in. For example, in Roche versus Cipla, I will not cite many, many cases which he has given judgments on, but just one case. In Roche versus Cipla, a request for an interim injunction was made by Roche, which was denied by Justice Bhat on the ground of public interest. The matter pertained to a claim of patent infringement by Roche against generic drug manufacturer Cipla. Going against the entrenched norm of routinely awarding interim injunctions in such matters, Justice Bhat refused injunction on the ground that such interference may lead to public's interest getting affected due to the huge price differential between Roche's and Cipla's drugs. Another judgment which I think created history was CPIO versus Subhash Chandra Agarwal, where he held that the Office of the Chief Justice of India is amenable to the provisions of the Right to Information Act, and the conclusion, which was eventually endorsed by the Constitution Bench of the Supreme Court. Sir, it is our privilege and pleasure to have you amongst us, and we are sure that the participants will learn immensely from your wise words. I would like to thank our guests of honor again to name Mr. Honorable Justice Najmi Waziri, Honorable Mr. Justice Yashwant Verma, and Honorable Mr. Justice Subramaniam Prasad, judges of the Delhi High Court, who were introduced to you all by Dr. Harleen in the morning. The Convenor Moot Court Society. She's one of the ablest teachers and the most efficient teachers that we have in our campus law center. My congratulations to her and Madhav. The judges, the guests of honor, they sat through the final rounds tirelessly. I've been watching since morning, and they have been motivating the young students. Thank you so much, sirs, and we hope that your association with Campus Law Center will continue and you will keep inspiring the young budding lawyers. With this, I wish you all the best for the prize distribution and leave the floor open to our esteemed chief guest, Supreme Court Judge, Justice Ravinder Bhat. Thank you so much.
Very good afternoon to the judges of the Delhi High Court, Justice Najmi Waziri, Justice Yashwant Verma, and Justice Subramaniam Prasad. Ms. Geeta Luthra, Mr. Sidharth Luthra, both senior advocates, Professor Dr. Alka Chawla, Professor in charge, Campus Law Center, Assistant Professor Dr. Harleen Kaur, Campus Law Center, and the most important people of today's audience, dear participants. Congratulations on successfully completing the 18th edition of the K.K. Luthra Memorial Moot Court competition. This moot has the distinction of being one of the best criminal law moot court competitions in our country, raising the bar of excellence with each edition. It is an absolute pleasure to watch young law students trying to decode the intricacies of the moot proposition, thoroughly researching the evolution of various nuances of criminal law, applying those to the facts presented, and framing cogent submissions, tasks which take the best of advocates year to master. Regardless of the result, it is these skills that you pick up which will bear fruit in the years to come, when I hope many of you will choose to practice before the law courts. This moot honors the legacy of the great Mr. K.K. Luthra, lawyer extraordinaire, who overcame significant hardships to establish himself as a formidable figure in criminal jurisprudence. He came to this country as a product of partition with literally nothing to his name. It was his conviction in his abilities and the courage to see them through in a fairly unpredictable profession, as the law was in the 1950s, and to a large extent continues to be, which paid off. I remember as a young lawyer being immensely impressed, even taken in by his craft inside the courtroom, and more by the impeccable sartorial style outside it. One of the few advocates who carried himself with poise wherever he went. I congratulate the efforts of his family, starting with the late Mrs. Nirmal Luthra in setting up this memorial moot competition in 2005, and his children, Geeta and Sidharth, both of whom are very well-known senior advocates and familiar figures in the profession, in keeping this legacy alive through it. Each time I'm asked to associate with the Campus Law Center, and this is a personal nostalgia, I invariably go down the nostalgia lane. Having entered this institution over 44 years ago, and graduated in 1982, one feels drawn to it each time one interacts with students or teachers. This institution has birthed several tall jurists like Dr. P.K. Tripathi, Dr. Latika Sarkar, Professor Bhupendra Bakshi, Professor Madhav Menon, each of whom were pioneers in their field, and some of whom went on to establish model law schools which have turned into these national law schools today. They inspired several generations of lawyers, judges, and stellar law teachers. Even today, 7 of us in the Supreme Court are alumni of this institution. Like in this moot proposition, matters involving the taking of life are the most difficult types of cases for judges to adjudicate. And especially more so when it comes to that corner, as I call it, of circumstantial evidence cases, the last seen theory. Cerebrally, they are very interesting. The motive of the crime and the modus operandi of the execution. They reveal a deeper insight into the darker human psyche. Practically, the reality is disheartening. Extraneous factors such as the background and economic status of the accused very often prove as impediments in the quest of a fair trial. Compounded by impossible fees quoted by legal representatives, legal counsel for various kinds of practices, some of which can be questioned, and having fixed rates to cross-examine only a certain number of witnesses. It is the poorest and desperate of need of such legal services who miss out. In the end, there is always loss of more than one life. Life of the deceased, the life of the poorly represented accused, and the lives of both their families. While advancements have been made by organizations providing free legal aid, I hope that in the future, just as you have done an outstanding job in representing the interests of 𝐋𝐿 and the state of Kildare before the High Court, you are equipped to assist those in need, thereby doing your bit in an attempt to neutralize some of the inequalities and iniquities that plague our systems and our society. To do so, you must further your interest in criminal law by cultivating a working knowledge of criminal procedure. For example, about the basics such as how to secure bail and what are the preliminaries before someone is arraigned in a criminal proceeding. The essence of personal liberties can effectively be protected by those who wield such knowledge. I hope that in the fullness of time, you will all cherish this experience and realize that it is not in the end what the prize is in it for you, but a thrill of the race. Well, I will not take up any more of your time because some of you will be biting your nails. And seeing how excited everyone is for the prize distribution, I will say this. Congratulations are in order for those who win, but more so for those who take away valuable lessons from their experiences and apply this insight to their advantage in the future. Thank you and wish you all the best. And once again, thank you, Mr. Luthra and Ms. Geeta Luthra for this sustained and continued effort.
Thank you very much, Your Lordship. Now we would like to proceed to announcing the results. We'd like to disturb Justice Bhat once again to announce and distribute the prizes for the best team, that is the winner of the competition, the second best team, that is the runners-up of the competition, and the winner of the best memorial for the competition. We would request Your Lordship, Justice Bhat, to kindly announce and give away these prizes. Sir.
Am I to announce all the three? Sorry.
Yes, sir, you have to announce all these three, sir.
Yes. The winner of this year's K.K. Luthra Memorial Moot Court is the team 1866 Symbiosis Law School, Pune, comprising of Vibhor Chandra, Sonal Jain, and Anushka Das. I congratulate all of you. They shall be receiving a cash prize of ₹20,000, a book from 𝐿KA Book Company, a complimentary 3-night stay at 𝐂𝐨𝐻𝐿𝐵 Resort in Goa, and certificates. The runner-up for this year's K.K. Luthra Memorial Moot Court competition is Team 1907 from the Faculty of Law, Jamia Millia Islamia, comprising of Seher Rauf, Janvi Rastogi, and Tanya Jaiswal. They shall be receiving a cash prize of ₹15,000, a book from 𝐿KA Book Company, and certificates. Congratulations, Jamia Millia. The award for the best memorial, comprising of a cash prize of ₹10,000 books from Ekta Book Company and certificates goes to team number 1825, representing Jindal Global Law School, Sonipat, comprising of Shalini Prem and Nanakji Ramjit Singh and Vanishka Tandon. Congratulations to you, Jindal. Well done, all of you.
Thank you, sir. Now, I would like to call upon Honorable Mr. Justice Najmi Waziri to announce the prize for the best speaker of the competition.
Let me say this, that what a privilege and a pleasure it has been to hear counsel for both sides today. I went through the written submissions. They were succinct, very well researched, with references to relevant legal precedents. And the manner in which you fielded the questions by the bench was really remarkable. I think this is truly a befitting tribute to a legendary and a towering personality in the field of law for Mr. K.K. Luthra, especially in the field of criminal jurisprudence. This annual moot court competition that goes on, this competition, I'm sure, is a thing which all students look forward to year after year. And I congratulate the Luthra family for it, for continuing this very important aspect in development and growth of a young law student who will be budding lawyers shortly. You know, the objective of a lawyer or any counsel is to persuade the bench to see your perspective. The judgment is, of course, something else. You leave that to the bench. But the endeavor would always be to let the bench see your perspective fully. And I think in this, the counsel today have done a marvelous job, truly marvelous job. The manner in which your thorough preparation, crispness of your arguments, and keeping within the time allotted to you, your poise. I can say this, that sometimes we wish that we saw this kind of presentation often in our courts. Now coming to the best speaker, right? Best speaker. Let me see what we've decided. This is a unanimous decision. The best speaker is award goes to this award of best speaker, comprising a cash prize of 15,000 rupees, a book from Ekta Book Company, and a certificate goes to speaker number 2 of team 1865, representing School of Law, Christ Deemed University of Bangalore, Sidharth Shrikant of Christ University. Congratulations to you, Mr. Shrikant.
Sidharth, join in, hand up.
You spoke very well, Mr. Shrikant. No dissenting opinion, no separate judgment.
That's Sidharth has just joined.
Yes.
Sidharth, you can put your hand up.
Gentleman here.
Yes, sir, he's here. He's here.
I wonder if you can hear us. Right. Thank you.
Thank you so much, sir. Now I would like to call upon Honorable Mr. Justice Yashwant Verma to announce the prize of the second best speaker. Your Lordship.
Okay, so to cut through the suspense, let me reverse the order and first award the prize. So the award for the second best speaker goes to Pandit Aradhana Swanand of the Christ University. It carries a cash prize of 10,000, a book from Ekta Book company and a certificate which would go out. So congratulations to Aradhana, and I hope she finds a bigger success as life goes on. I'm extremely grateful to everyone at the Campus Law Center, as well as the participants for having given us this occasion to meet on a Sunday and hear some scintillating arguments. And thank you so much to Sidharth, Geeta, and every member of the Luthra family. I think nothing is greater or bigger than acknowledging the blessings of our forefathers, which has carried us till here, of all that the profession has given all of you, and to give some of it back. And I hope this tradition continues over the next many generations to come. Thank you all. For the speakers, may I just put in one note, and that is to just reiterate what Justice Bhat said. Don't get disheartened by the long climb which the profession unwaringly does place on all new entrants. But having heard all of you, I am very, very confident that our profession is in safe hands and will travel many miles ahead. Thank you. Thank you, Madhav.
Thank you, Your Lordship. Finally, I would like to call upon Honorable Mr. Justice Subramanian Prasad to announce the prize of the second best memorial. Your Lordship.
Thank you so much. Justice Ravinder Bhat, Judge Supreme Court, Justice Waziri, Justice Yashwant Verma, Judges of the Delhi High Court. An extremely well spent morning and afternoon. Terrific performance by all the participants. Immaculate address, extremely good presence of mind and capacity to handle courts. Only one advice, that this profession is not a 100-meter sprint, but it's a marathon. And that please don't run towards what you call as initial success. It's only long time that later you will realize where you are. The award for the second best memorial, comprising of a cash prize of 7,500 from Ekta Book Company and a certificate, goes to Team 1892, representing Maharashtra National University, Aurangabad. Congratulations.
May I take the liberty of saying something to Justice, sir, you must have, Justice Bhat, sir, you must have enjoyed the names of the dramatis personae. And I'm sure that Professor Dr. Alka Chawla and the teacher in charge, Dr. Harleen, also, these are wonderful names here. Frisk, University of Kildare, and what is this? County of Calumny, Lucky Strike, Bob's Butchery. This must have been a delight for all those who kept those names. Yeah? Fabulous time. Mr. Pep, Mr. Chancerton. It must have been a wonderful time to keep up the whole research. Chancerton. Wonderful. Good fun.
But sir, let me tell you, we are really missing the fun. You know, in physical, when you have the prize distribution. No, I'm not. I was just saying, am I audible?
Yes, now.
Yes.
That, you know, the physical prize distribution ceremony is a completely different scenario, where you find, when you look at the, you know, faces of the students who are just jumping with joy, and all of us looking at them, you know, the young blood, the way they react, that is something which we are really missing. And I'm really praying to God that next year, Sidharth, Geeta, we all have you in person with all the judges in person and all the participants in person at Campus Law Center. Though we don't have a good infrastructure, but the joy that we give to everyone is just cannot be measured. And I personally thank all of you for all this. Thank you so much. We can't even hear the laughter, the fun, you know, sitting at home.
We would request all the prize winners to kindly raise their hands so that we can switch their cameras on for the benefit of everybody present here today. So we request all the winning participants to raise their hand through Zoom, besides those who are already here as panelists. So the best speaker winners, the best memorial winners, those teams, you request that you kindly raise your hand. We'll promote you to panelists. You can switch on your videos and we can enjoy some of the energy that Alka ma'am is talking about.
Very good. Congratulations.
Yes.
Congratulations.
Now, all that is left for me to do is call our mentor, our guide, and well, a father, more than just a father figure to this competition, somebody without whose tireless energy, generosity, and mentorship, this competition would just not be possible. It gives me immense pleasure inviting Mr. Sidharth Luthra to give the vote of thanks. So,
thank you, Madhav. Justice Bhat, Justice Ravinder Bhat, Justice Najmi Vaziri, Justice Yashwant Verma, and Justice Subramaniam Prasad. Thank you so very much for sparing your time today. On behalf of the eldest of our siblings, Dr. Meera Luthra, and on behalf of the rest of the family, the siblings and the in-laws, that is the outlaws and the in-laws, it is my pleasure to thank you all for being here. It's been an interesting event, and I must tell you, over the years, we've seen a lot of panels. Yours has been one of the most interactive panels, so we were also enjoying it, as I'm sure the students did. I hope so many questions don't come in. Geeta or I or any of others are in court next time. That's the only worry. I must tell you that it's been a great privilege to do this. And when we lost our mother, there was an issue whether we would continue that year because, you know, her demise came shortly. But then even at that stage, we felt that the show must go on, and that's what our mother desired. So we've tried to do this in COVID times. And as Alka said, hopefully next year we'll be there physically together. And Alka, there is one thing you forgot. At the end of the competition, there is a lovely meal that you give us. So don't forget that. That brings a lot of smiles to all of us. We look forward to next year in physical space. Now, just to a few words, Justice Bhat has been a great support to us over the years. He has been here in different capacities. He's judged this competition many times, and he's always very engaging and very kind. There are two things I want to share about Justice Bhat. He mentioned my late father's sartorial sense. I always find it fascinating when I see him wearing his very classic hats, and I always enjoy it. And I remember my late father when we meet occasionally, and I see Justice Bhat wearing that wonderful hat with a slight tilt. It's wonderful to see you, sir. Brings back fond memories. But another aspect is that in an era when we are concerned about liberty, Justice Bhat is one of those wonderful judges, not rare, but wonderful judges, who is sensitive to liberty. And if you see his wonderful decision in Sushila Agarwal, the Constitution Bench, it exemplifies the law of liberty and how it is to be understood. It is a very important lesson. That apart, Justice Bhatt's humanity and his concern for the downtrodden was seen in the lockdown when he went out and worked and helped migrant labor. And that is the mark of the man. Thank you so much, sir, for spending time and gracing this occasion. It's really kind of you to be here. I must also thank Justice Najmi Vaziri, who has been a senior colleague, like Justice Bhat, an alumnus of the CLC with us, and much senior, of course, to us. And it's been a privilege to have you here, sir. I've known Justice Vaziri as a senior colleague at the bar, then as a judge for many, many years. And apart from his other interests, the passion with which he has worked on the environment of Delhi in changing the face of the ridge is something which is to be understood. It can only be understood with somebody who understands what this city needs. We all go about our daily work. We see trees being cut down. We see that our city is not what it used to be. But then you come across rare personalities who believe that the cause of justice is not just delivering decisions, but by being creative and ensuring that social justice and environmental justice follows. It's not just an adjudication of legal matters. And he's used powers which are vested with him under the Constitution and the laws to do that. Thank you so much, sir, for spending your time and being with us today. It's been a great honor and a great privilege to have you. And we hope that all of us learn from you, and the students also are inspired to carry forth, learn not only from your judgments, but also from the directions and the concern for the environment and for society itself. Thank you so much, sir, for being here today. Justice Yashwant Verma, our families go back to a time when I used to visit him at Allahabad when he was younger, and so was I. And I've known Justice Verma again in different capacities. I've seen him in Allahabad, had the privilege of being in his court. Another individual who, though he was government counsel for a long time, he never lost his sensitivity to the rights of the individuals. And that's been the hallmark of the gentleman. Thank you so much, sir, for being here. We are so happy to have you in the Delhi High Court, which is my parent High Court. It's been a privilege to have you here. And we can see the impact you are having along with others, along with your colleagues. And we hope to have a lot more from you, a lot more judgments, a lot more expansion of judicial philosophy from you in the coming years. Thank you so much for being here. It's a real honor to have you today. I must also thank my contemporary, my friends, Justice Prasad, K.K. and I, we were all together. I've seen Justice Prasad in different avatars. He was AGA, he's for the state of Tamil Nadu. He was the counsel for CBI in some very, very contentious cases, and yet maintained his dignity and his concern and his sense of fairness. He was very particular to ensure that he would never shirk from his duty while maintaining fairness to the system. It's been a privilege to have you. And what I must tell you, for the young lawyers, like the other judges, there's an easy sense of humor in his court. There's always a pleasure to walk into court. I have never walked out without a smile. And if somebody even ever gets stressed, there is always the disarming smile which puts us at ease. He's had a bit of a journey from Delhi to Madras High Court and back, but it's so good to have you back in the city where you've grown up, sir. And it's a privilege to be in your court. Thank you so very much for sparing your time and being with us today. There are others who need to be thanked. My dear, dear friend, Alka Chawla, who's a great support. Alka has been the convener of this society. She's a professor in charge, and she's made sure that we've met a lot of adversities. We had a lot of concerns when we decided to cancel it in January, but Alka was the one who showed us the light. Thank you so much, Alka, for supporting us. Harleen, where is Harleen? Harleen, you need to put your hand up somewhere. Harleen and her team of volunteers. Harleen, you're lucky you're not in court. You would have been in trouble in a car. I know you're in transit, but Harleen is a dear friend. Harleen has been supporting this moot court for very many years. And it's been an honor and privilege to have you here and to make this competition. The rest of Harleen's team is sitting in the office and they're working away. And Harleen is transiting because she had to do things at 2 locations. Thank you, Harleen, for being here.
Thank you, sir.
Madhav Goel and his team. Madhav, you're around. You've been doing this, running this competition very well. And it's been a real privilege to have you here. Justice Waziri talked about the unique names, the creative names in this moot court problem. I hope Faraz Makbul is here. Faraz was the author of this problem. I hope the students will not go after him with brickbats. He worked very hard to have a creative problem and tried to balance it out. Thank you, Faraz, for supporting us. Our young friends like Faraz are the ones who, Faraz has raised his hand. I think you need to make him a panelist. And it's been really nice to have you here, Faraz. Please put on your camera and and we're bringing you as a panelist. For some reason, you're outside. I'll go on with the thanks, and meanwhile, we get to see Faraz as well. I must also thank my very dear friend Dinesh Tudeja. I must tell you, every year since the year 2005, He has come to us. There's Faraz. Faraz, please raise your hand. Thank you so much for being here. Thank you, Faraz. Dinesh Jadeja of Ekta Book Company has been a friend since I joined the legal profession. The family's been around for a long time. And Dinesh makes it a point, and every year he reaches out to us. We have never had to call upon him, where he said, he always says, he makes sure that every student who participates in the competition gets a law book as a gift from his side in honor of the memory of my father. And it's always, he chooses the books with care, and he makes sure that they are selected and they're sent to students. So it'll be of interest to students and to engender in them a sense of understanding and appreciation of the law. So Dinesh ji, thank you so much. He's around here somewhere, but I can't see him, so I won't take more time. I must also not fail in thanking the initiator of this moot court. He has been a professor to many of us, Professor Rajiv Khanna. He is the person who began this wonderful competition, and Professor Khanna has been a great mentor to all of us. Even now, he calls me, asks me how the moot is going, knows the dates, checks up, and every year we've had a physical moot court. Sir has been sitting on the front row, always guiding us, supporting us, and being here. So thank you very much. And thank you, last, I must say, the participants. We had 90 odd registrations of teams, 76 given their memorials. We shortlisted them to 60 plus. I wish we can have you here next year in physical form with all of us facing each other and being together in the same environment at the Campus Law Center. You are the guys who make this competition work. We would not have reached that far from 14 teams to 90 plus universities in 18 years, but for your support and your generosity of time. Thank you so much for all the efforts. You've not all made it, but some of you have done very well. Some have succeeded, but the others did a brilliant job as well, Meera. Thank you so much. So kind of you to be there. And with that, I will end my vote of thanks. Thank you so very much. Madhav?
So with that, we come to the conclusion for today's proceedings. We thank everybody for being being here with us today, and for being part of this year's edition of the K.K. Luthra Memorial Moot Court, and making this by far, making this a benchmark for how competitions should be organized in the future. Thank you so much, and again thank you so much everybody for coming today.
Thank you.
Thank you.
Thank you, Sidharth.
Thank you.